Hello everyone. Welcome back to Mindful Contract Administrator. Today we are going to talk about another compensation event which has been mentioned within the NEC 4, which is known as access to site. What is access to site? What will happen if you don't give access to site? If there is any property which is owned by someone, you normally have to give them access to that particular place unless it is known as a trespass, the tort of trespass. So, first let us look at the FIDIC scenario regarding access to site. FIDIC has got two subclauses within its 2017 version pertaining to access to site. Number one is subclause 2.1, which is talking about the initial access which has to be given to the contractor in view of proceeding with his works, and what are the compensations, what are the consequences of not receiving the site on time. Then there is another subclause within FIDIC 2017 version, that is 11.7, which is signifying the end date of the access of that particular contractor into the site. So in subclause 2.1 there are some very important terminology, very important phrases which has been used by the FIDIC drafters. One is, it says right of access. Other one says possession of. What is meant by right of access? What is meant by the possession of? For example, imagine that you are going to rent a house from a landlord. What will happen? He will sign some papers with you. There will be a rental agreement between the parties, isn't it? So that rental agreement gives you the legal right in order to enter into the property of another person. When it comes to the possession of, the meaning of the possession means that you are allowed to come into that particular place by physical means. For example, you are being given a key in order to enter into that particular house. So right of access would not suffice if you don't have the proper mode of entering into that particular house. So that is the difference between these two. There is a very important phrase which is mentioned within subclause 2.1 of FIDIC Red Book. It states the right of access is not exclusive to the contractor. What does that mean? What does that mean? Imagine that you are in a hostel in a university. Normally you have shared accommodation, isn't it? I walked down the memory lane about my university days. During my hostel time, I shared a room with 3 of my batchmates. So you are enjoying the facility whilst the others are enjoying the same facility as well. So we are coming into that particular scenario in a different video, but that means the right of access is not exclusive to the contractor, means that it needs to be shared. It has to be shared amongst other stakeholders of a project. Now, when it comes to the NEC compensation event, it uses very similar type of terminology. Instead of right of access, it says allow access. Instead of the use, instead of the word the possession of, NEC uses the use of. So it is almost the same. But there is a difference between the compensation event in NEC when you compare that with that of FIDIC 2017 version, related to the timings of the right of access which is being implemented. For example, the FIDIC terminology says the right of access has to be given as per the dates stipulated within the contract data. In the event that it is not available within the contract data, only that you have to go for the program. But the NEC terminology says, NEC compensation event specifically states the right of access has to be given as per the date specified in the contract data, or as stipulated within what is known as accepted program, which is approved by the client, which is the equivalent of the employer. So whichever the later date. So in practical terms, NEC allows either to use what is given in the contract data or to use what is actually meant by the accepted program, which is the most practical scenario. So there is a difference between what is given in the FIDIC terminology as well as NEC terminology. So when it comes to the compensation event itself, if you do not give the right of access or allow access to the site, if the employer or the client does not give, the contractor gets an opportunity to claim for time and cost. When you talk about the right of, the phrase right of, it comes into my mind about right of light, right of way. There are many other terminology as such. So I'm going to talk about them as well in my future videos. I hope you enjoyed this particular video, and we'll meet in another video as well. Have a nice day.